it's around that time right here on KAZ Radio where we have one of the most hottest shows once a month, none other than Family Court, with my friend and yours, Maryann, Dybiec, and attorney Eric Cherry. How you guys doing?
Great. Yeah, doing good, Larry. I missed you for a couple of months.
Yeah, I missed you too. Well, welcome to the new gig, new gigs, I should say. And,
in our beautiful new studio. It's great here.
Yeah, and you got some wonderful, beautiful guests, man.
Yes,
I've never seen such a handsome crowd of folks in here ever.
Thank you.
Thank you so much. Would you like to take it away, Mary?
First, I'm going to read our disclaimer. Thank you for listening to our show. We hope we can help you maneuver the family court system by providing you with some examples of how court works. We ask that if you do call in to not give any last names or judges' names in a case to protect everyone involved in your legal issues. Also, please note, no attorney-client relationship is formed by any answers given on our program. These answers should not be your only inquiry. You should schedule an appointment and seek the advice of an attorney to fully explain the facts of your case, as all cases are different, so the attorney can make an informed opinion and advise you of your rights. If you think you can't afford an attorney, please call Children's Rights Family Advocates or the Bar Association so that we can help you find an attorney that you can afford. It is not recommended to maneuver the family court system as a pro se litigant or uneducated on family court issues. And thank you for joining our show. Today we have two attorneys with us. We're so lucky. We have Jessica Jump, who's going to talk to us about guardian ad litem issues. And we have Samantha...
Already started on a good note.
That would be Samantha Salamon, man.
And how did we know we were going to screw that up? Who is going to talk to us about protection issues, or protection orders, I'm sorry.
Yes, ma'am.
So we're going to start with Samantha, and you're going to explain to us exactly what is a protection order, who uses it, what is it good for?
Sure, not a problem. So, in starting off, before we go into depth with regards to the specific type of protection order we're going to talk about, I would like to give a general understanding of what the types of protection orders are that are available to individuals. So there are two different types of protection orders. There is a temporary protection order, which is affiliated with a criminal case. So typically, if someone makes a police report, if a victim makes a police report, and there is a case that's being prosecuted, you can then opt into what's called a temporary protection order. We also coined it a TPO because it's much easier to say. That's with the criminal justice system. With regards to a civil system, typically a lot of times when you are a victim of certain crimes, you don't necessarily want to go to the police to make a police report, but you still want that protection aspect there. So you can do what's called a civil protection order. A civil protection order is dealt with in a different court system. The domestic relations court typically deals with it, and depending upon the jurisdiction in which you're approaching. For Cuyahoga County, it is the domestic relations court.
Is there talking about civil protection orders, is there a difference between a domestic violence civil protection order and a civil stalking protection order?
So actually, yes, those are two of the three options of civil protection orders. There is the domestic violence, there is a stalking civil protection order, and then there's the sexual-oriented civil protection order. Each of them have different requirements. With regards directly to your question, with the difference between a domestic violence protection order and a stalking protection order, there is that element of the residential. If someone is living with you, you would go geared towards the domestic violence civil protection order. If they're not living with you and there's more than one incident of a stalking issue, then you would go towards the stalking civil protection order.
Okay, is there any difference in the kind of protections provided by those orders?
Well, it could vary. Obviously, it's circumstantial. As an attorney, my favorite line is, it depends. It really just depends upon the circumstances. Obviously, domestic violence protection orders, because there's that residential element of the domestic violence protection order, or CPO, I like to coin it because that's the typical type of CPO there is. There are various elements that you have to point out as to who's going to be taking the property or ownership or possession of the property. If there are kids involved, who's going to be dealing with parental rights. With regards to a stalking protection order, that tends to be a little bit more of a hazy area to go into, because a lot of the times, unless you actually know, one, the name of the individual who you're claiming is stalking you and where they live, you have to fulfill the service requirements of it. A lot of the times, people don't have that information when they're trying to obtain a protection order, but those are required elements in which you have to meet.
I see. So tell me in general, the types of protections that are provided by really any protection order, because at least in my understanding and my practice, we're talking about communications, we're talking about remaining away from a person by a certain distance, and some of the other types of protections that a person can expect if they have a protection order.
So obviously there's a template protection order that is given out by the courts. And in that template, I think there's maybe 16 or 17 different positions that are templated. But what happens is the judge will check anyone that they feel is applicable to those particular circumstances. Some of them, as you already stated, it was like you can't be within 500 feet or a certain distance that the judge feels is necessary for that particular circumstance. You cannot have any interference in their daily life. A lot of the times with a lot of my clients who I deal with, mail tends to be an issue. They redirect mail or they go to their place of employment, and that tends to be, unfortunately, a very big issue. On top of all that, so you have no contact order, you have non-interference with the protection. Also with regards to parental rights, if you're dealing with a family member or a spouse or somebody who you have a child in common with, parental rights will be divided. For the most part, depending upon where you are in this stage will determine upon what type, how the parental rights are going to be distributed. A lot of the times when you're in the first part of getting a protection order, and we can obviously go through the procedures next, when you're in the first part, a lot of the times if there's a child in common, they'll suspend all rights to the child, all your parental rights.
I have a question.
Yes.
Why do they do that?
So it goes into more of the procedure aspect. But initially, when someone goes in and they apply, the first part of getting a protection order is filling out all the paperwork and then getting what's called the ex parte protection order, or without a party protection order, meaning only one party is going in front of the magistrate and or a judge and determining whether or not in that immediate circumstance a protection order is necessary. With that being said, it's only for a short period of time, because then after either way, whether you're granted an ex parte protection order or not, there's still going to be what's called a CPO full hearing that is given within 7 to 10 business days from the date of issuing the protection order.
That's a lot. It has to be heard within 7 to 10 days. If they give an ex parte, if they grant the ex parte protection order, it has to be in 7 to 10 days.
Yes, legally, yes, it does. But what happens is, so upon the issuance of either a protection order or the notification given to the other party, identified as a respondent or the abuser, the alleged abuser in this situation, they have the opportunity where they have to go there and they have to present themselves, and they are the ones who are in control of the next steps in the process because they're the ones who are being accused of it. So a lot of the times individuals will go there and they're like, I don't know what's going on, I don't understand, I just got this protection order, what's going on with this? So they have the opportunity, they can either continue, so they can get an attorney and they can go through all the evidence, or they can just go through the evidence themselves. Obviously, I would highly encourage everyone to get an attorney in that particular circumstance because a lot is typically on the line.
Yeah, I do too. I highly encourage people to get attorneys in that position.
Exactly.
Right, like you tell somebody.
You're asking me? What do you think I'm going to say?
I don't know how many times I call him Eric Domestic. Oh, Eric, that was the first case you started on for us.
For you, some domestic
he was in
violence.
court. I saw him in court, and I was with a client. I'm like, you can't go without a lawyer, Eric.
It's true.
Yeah. Mm-hmm.
I'm still working with him.
Yeah, really? Oh, that's right. That was yeah.
Yeah.
Confidentiality, people.
So I'm sorry, we were talking about the family piece of this. And
The 10 days that they have to wait.
Oh, yes. So upon getting the notice that there's going to be a CPO full hearing, the respondent comes in. They have 3 different options of what they can do. They can either, one, ask the court to continue the case, which they do have a legal right to do, whereby they can get an attorney, or they can at least get through the evidence and get a better understanding of what the heck is going on. 2, they can go forward with the trial. They have that right at that day to be like, you need to prove this on this day in front of the judge and me. Or the third option is they can try negotiating. The court has advocates in which they will help in trying to see whether or not there is what's called a consent agreement, which could occur, which is basically both parties agreeing to a protection order with certain parameters that appeases both parties.
Okay, so, do you have a question?
So if you are denied at the ex parte level, do you still get the full hearing? Just for people that are trying to obtain the protection order.
Yes, you do have the right to the full hearing.
Okay.
Because again, in the end of the day, it's kind of, you are making an allegation to the court. And the ex parte, the reason why that is given is because there is an imminent threat at that exact time, or the individual who is making the allegation. They are the one, they're saying there's an imminent threat right now that if I don't get this protection order, I could be threatened with my life getting endangered. So even if the judge is like, maybe an ex parte is not necessary, but I'll still give you your day in court. I'll still allow you to present evidence. I'll still allow you to give witness testimony into determining whether or not a CPO or any type of protection order is necessary for the circumstances.
Okay, so you talk about presenting evidence and letting the court know why you need this protection order. Can you talk about a little bit about the burden for those people, for the petitioners?
Good question.
Yes. So basically what they need to prove is they need to prove to the court that a reasonable person would feel that they are in imminent danger, there is an imminent threat to their well-being, essentially. Now, what exactly does that mean? Here we go again. It depends. It depends. There are so many circumstances to take into consideration. But again, the standard is a reasonable person, and you have to prove that there is an imminent threat. Not just, I kind of am afraid of him, he's kind of being awkward. No. There's an imminent threat. CPOs, unfortunately, they are a very valuable resource that unfortunately tend to be taken advantage of in the court system. I think everybody here can apply to that it really, unfortunately, is taken advantage of a lot. But that being said, obviously, the court is always in the default of, I want to protect people as much as I possibly can, but they have to show adequate evidence that meets that burden.
Okay. And is that the same when you go to the full hearing? Is it the same burden for both parts of the?
In my experience, the burden at the ex parte level is higher because there is no respondent. But at the full hearing, it is a preponderance of the evidence standard. Okay. And for those of you out there who are not legally trained, that would be slightly more than half. More evidence than the other side has is the preponderance of the evidence standard. Okay. So it's a little bit easier at full hearing. That said, in my experience, the ex parte orders are routinely granted.
Yes.
Not always, but correct. Almost always. Okay. If I may, I think Maryann was making an implication earlier when she asked you about why parental time is suspended at the ex parte level. And I think what she was getting to, you kind of mentioned yourself that the process is abused. In your experience at the ex parte hearing, at the first hearing, when it's just one party giving the allegation.
Yes.
Is the court cognizant of the difference between the abused party, alleged abused party, and any children involved? Do they apply the standard independently to each? Or do you think it's sufficient for many courts to find that the person making the allegation, if there's enough evidence for them, that they'll just go ahead and protect the children too?
So in my experience, the court does not want to terminate or suspend parental rights, because that's a very big step for the court to take. And in the end of the day, the overall court system wants to encourage parents to be involved in their children's lives. But what the court does, from my experience, what the court does look at is what the alleged incident is. So when you are going for the ex parte or when you're going for the full hearing, you can only specify and talk about the last incident in which you're coming here for. The court may sometimes, depending on circumstances, entertain a little bit more of a history, but typically it's the last incident the court wants to hear about. So that being said, if in that last incident in which the court is going to be interested in actually hearing about, if that incident has any involvement of the children, it has been my experience that yes, the kids will be the parental rights will be suspended temporarily during the ex parte CPO, but what does it mean for the children to be involved with this? Not necessarily that the children themselves are actually abused. Sometimes if the children are just in the house, if the children have seen anything, have the children heard anything, because in the end of the day, we don't want these poor children to be traumatized any more than what they have or than what they've already been exposed to. So typically it's with regards to determining or the suspending of parental rights for the protection order, the child had to have been affected in some way, shape, or form in this.
Okay.
How do you prove that the child was affected? I mean, that question did come up with people this week.
It depends. I'm sorry. I know I just keep deferring to that, but it's so applicable to so many cases. A lot of it can just be stated, depending upon the age of the child, honestly, is something that's taken into consideration.
Would the child come in and testify?
Very, very rarely. I've never experienced that, and the court really will defer to never doing that.
Really? Mm-hmm.
Yes.
Well, that's good to know.
Yes.
Then what, a psychology report?
So typically, honestly, the testimony is the biggest piece of evidence in most CPO hearings. The alleged victim's testimony. If the child is a very young child, like 5 years or younger, typically just what the alleged victim is stating, that the kid was in the room with me, then the judge will defer to that. But with regards to sometimes when the children are older, they may. Again, the court does not want to get the children involved as much as possible. And typically when I have never heard of the children getting involved. It's typically always deferring to the witness testimony, to be honest.
Well, and not to dovetail into our second topic, but isn't it possible in a CPO hearing to have a guardian ad litem appointed to represent the child?
It has never happened in any of my cases.
But it is possible.
But it is possible, yes.
Yeah,
Because
that does let us kind of segue into
there we
the
go.
guardian ad litem.
Beautifully done.
So let me ask you, would a guardian ad litem, let's just take the DV out of it, would a guardian ad litem be able to speak on behalf of a child who, say a 12-year-old comes to you and says, I am traumatized? Is that enough for you to go to the judge and say, Your Honor, this 12-year-old is traumatized? Or would you have that child go to a psychiatrist and have a documentation that the child has nightmares? And what's the right answer? Would a guardian?
Well, it depends on whether or not a guardian ad litem is assigned to the case already. So if a random 12-year-old off the street comes and tells me that, then as a GAL, I'm a mandatory reporter, so that would trigger a call to whatever Children and Family Services agency has jurisdiction over that child, whether whatever county it is.
Say the family's thinking about pulling a guardian on the case just because of that.
I'm sorry?
What about a family who doesn't have a guardian applied to their case, but is thinking about hiring a guardian on their case because they're worried about the mental status of their children? Would a guardian ad litem be an asset to that?
Absolutely. So just to kind of go back a little bit, a GAL, a guardian ad litem, is typically an attorney. There are some non-attorneys, but those are reserved for Children and Family Services cases, who represents the child's best interest. What it shouldn't be confused with is representing what the child wants. So that's what parents are constantly, what I'm hearing from parents. Well, didn't you hear what they said? This is what he or she wants. Well, there's a lot of factors that have to be considered. So it's representing the child's best interest. So you do an investigation, talk to the child, talk to the parents, anybody that may or may not be important. You get a court order that gives you independent access to the child's medical records, school records, anything that may be helpful. That you don't need the parents for. Now, if you've got a 12-year-old child who's expressing some anxieties, maybe has witnessed DV or been a victim of DV, then I would always recommend a GAL in that case, because it gives your child a voice, and then the GALs can kind of determine where is this coming from. You see a lot of situations. Well, I don't want to use this. We all know as attorneys the term parental alienation is pretty pretty loaded. However, but maybe some influence from a parent, and you can kind of determine that. If the child is experiencing that much, I would hope that the parent that's alleging the anxieties is getting some mental health treatment for that kid too. So that would be helpful and important. And again, as a GAL, I can get that independently from, access to the parents, which not all institutions actually understand. But
is there a mechanism for you to be assigned on a domestic violence civil protection order case?
So I have never been assigned on a domestic violence case that's solely that case.
You can put a guardian on those?
Not to my knowledge in Cuyahoga County, not. And I had a brief experience recently where I had a client, we modified a protection order which included his child. In some discussions with the magistrate, he had expressed that, we can change something here with his visitation, but really juvenile court has original jurisdiction in that case because they weren't married. And his statement was because we don't assign GALs in this court. So at least if it's solely a domestic violence case, only a domestic violence protection order in Cuyahoga County, they do not assign GALs in those cases. So, but I would imagine if there isn't already some custody action somewhere, whether it's domestic relations court or juvenile court, that there's, you can get a GAL through that way.
Typically, they're very hand in hand, though, it seems
Yes.
like, between the protection order, and this is where I feel a lot of the abuse actually occurs of protection orders, between the protection orders and a custody battle.
Oh, hello.
Oh, yes, absolutely.
It's amazing
I don't know what you're
all that I
talking
see of that.
Yes.
Yeah, it is. I remember years and years ago, this was 20 years ago when I first got dragged into this, and I was going through a divorce, and my attorney said he could get my husband out of the house by filing a domestic violence protection order. And I was like, you know what? He never hit me. I fired him 3 times. I'm like, you are not going to convince me. So, again, this was 20 years ago, and a lot has changed in 20 years about the domestic violence. But, I mean, I saw it 20 years ago, and I was appalled that he was like, oh, no, it's okay. We can kick him out of the house. He could live in a cardboard box. I'm like, you are talking about the father of my children. So you're fired. He would call me back and he'd go, I'm so sorry. And I'm like, okay. So I let him continue because he knew my wishes. You're not going to pull this. You're not. And I was new at this divorce, family law stuff. But yeah, it's very much used, the domestic violence protection orders.
And at least in my experience, when you finally get to a trial on the custody case, one of the factors of the best interest analysis is where the child has gotten comfortable, effectively. What the routine is for that child, who they're used to seeing on a daily basis, and what have you. So it's the dirtiest tactic on the planet, but if you go and you get a domestic violence civil protection order that temporarily suspends the rights of one party, and then you get that transferred over into after the full hearing, either by consent order or what have you, if that is a long-term order, and then all you got to do is drag your feet at the custody court and make that sit around for 8-9 months, right up until the Supreme Court limit, and then you make the argument at trial that, well, child's comfortable, so leave it.
Gee, how do you know about that?
Because I have never done it before.
Such a passion.
To that same point, it also diminishes the parent's ability to communicate. So even if the child is not protected on the protection order, say if they get a 5-year order or something, then the person who is protected can make the argument, well, we can't have shared parenting. The whole point is, so it's a tool that people abuse.
I'm amazed where these people learn these tricks. That's what amazes me. What do you guys have, little coffee clutches? Somewhere? Oh, here's a trick you can use. Here's a trick you can use.
All you have to be is on the receiving end of that one time. And then
So
you
never forget it.
It's word of mouth.
It's not even word of mouth, it's experience. You get into court, okay, so let's take I'm going to stereotype this a little bit. Man walks into my office, tells me this story. He's like, she's taking the kids away from me. Here's the case, civil protection order case. I get started with that. Maybe we sign a consent order. Maybe we even get the kid off of as a protected party. So it's just the 2 parties. And then, you turn around and you go to domestic relations court, or into juvenile court, and you're fighting against that presumption that there's a protection order here for a reason. And they're always kind of looking at your client like, you're a little dangerous, and that works against you for the rest of the way. And so that leverage in a custody case is very valuable and horribly abused.
Yes, very much.
It's unfortunate, but...
It's getting better, though, I think. Don't you guys think it's getting a little bit better than what it used to be?
That's not my experience, but if it's yours, I mean, that's great to hear. But from what my experience is,
I don't hang
no.
around there anymore because it's just too depressing. I'll just let you guys do it.
Well, thanks.
No problem.
Yeah, no, I don't think this almost exact same scenario occurred. I actually just had a case whereby both parents were charged with an abuse neglect case, and in juvenile court, both prosecuted. I'm representing the mother because she's been a victim for several years of domestic violence. And dad went to domestic relations court and got a civil protection order because of the allegations that were in the juvenile court case.
Wow.
And so my client is like, what do I do? Like, I can't see my kids, I can't be at home, I can't do anything, and this is somebody who's been a victim for several years. And so, in my opinion, no. That strategy, that tactic has not changed.
Okay, real quick, I just want to give our phone number out. It's 216-298-1554 if you want to call in. We also have questions, email questions that we got. Jessica, you answered one already. You didn't have too many questions. Everybody knows how to do your job. I saw this. Did you guys see this JC3 message? What is Did you read that message on Facebook? I'll have to take that one off there, but let's see. Okay, here's a good one for a guardian. Mom or one parent makes false allegations. Are there any punishments for that? It was actually found to be false.
From a GAL perspective?
Let me give you the whole story.
Okay.
Mom or dad makes false allegations of sexual misconduct.
Okay.
Then it's found to be unfounded. Okay, I mean, detectives come, police show up, CPS is involved, no findings, right? Okay. Is there any punishment for the party who made those false allegations?
Well, from my perspective as a GAL, I wouldn't call it punishment, but it certainly factors into what's in the best interest of the child. And if they are being exposed to a parent who is trying to influence them to that extent and putting them through an investigation, having social workers and police detectives come in and talk to them about these very sensitive issues when it didn't happen, just to make this other party look worse or to give you a leg up in the custody case, I don't want to call it punishment, but my recommendation would probably fall away from, from that party.
That situation then?
Well, certainly get the child some mental health services to deal with that. I would probably ask for a psychological evaluation of the parent who made the allegations as well. I mean, there's independent ones; those can be very expensive. I'm sure you guys know. The juvenile court in Cuyahoga County has a psychological diagnostic. It was escaping me for a moment, which they're now charging private clients for. I think it's $500 or something. Are you? Yeah. Which is still, I think, far cheaper than if you went to somebody independently, and to see, what's going on here. Why are they making these allegations? And if it continues, then you have to start thinking about restricting visits with the kid so that they can't start having or keep having these types of conversations with the child. If they're willing to go that far, how much further are they going to go?
Right.
So restricting visits. Supervised.
Even, if I may suggest, even from the quality of the evidence that would come from their testimony at trial, they've clearly made a statement, a pretty severe statement, that turned out not to be true, and wouldn't that impact upon their credibility? So once you get to trial, whatever testimony they would offer would be a little bit less valuable because we know at least this one time you pretty clearly lied.
Yeah.
Would that be how you would take it?
Yeah. If I were the attorney in this case, I was just thinking of it from GAL's perspective because.
Have you ever seen somebody lose custody over false allegations of sexual misconduct?
Not personally. I did work for a firm for about almost 5 years, and we've had, there was one case where somebody went so far in those types of allegations that that parent ended up with supervised visitation and losing custody of her daughter.
Yeah, so be careful. Don't tell them why.
No, but really, I mean, you shouldn't put a child through that. You shouldn't put a
Right.
child through what happens when when you utter those words.
I wish everybody would get that. There are so many people who just don't get what harm they're doing to their children. And none of us are perfect.
Right, of
But
course.
we can at least try.
You know, one thing that I have experienced, and I'll say this till the day I stop practicing, family court custody issues, they are nasty issues.
Yes.
Parents are willing to go to extremes to what they feel is protect their child or protect the best interest of their child. And to me, I feel that a lot of my clients, I kind of have to give them reality checks. Is, you know, we're going to advocate and we're going to try getting your goal, but it needs to be practical. Because a lot of the times expectations are it's either one extreme or the next. Either you're going to win big or you're going to lose bad. And it's like, is that what's best for the child? You know, and in the end of the day, when it comes to juvenile court, I tell every single one of my clients this, and I don't know if it's a bad thing, but I tell them, I was like, I don't really care that much about you, and I don't really care that much about the other parent. I care about that child. And I want that child to be in a safe place as well. I'm going to advocate like crazy for your position in this case. And if I feel that what you're saying is 100% credible and what you want to happen, I won't leave your side. But in the end of the day, I kind of have to keep taking my clients a step back and look at the big picture. It's like, is really doing this beneficial to your child? Is really doing this going to be the best circumstance? Because in the end of the day, 99% of cases, correct me if I'm wrong, whether that child, I mean, you got at least 18 years with that other person.
Yeah, we all know
And-
it's much more than that.
Well,
Yeah.
exactly. But again, it's kind of like you had a child and, you know, you have to deal with this person. Unless, obviously, there are circumstances which are egregious and, you know, you don't have to deal with that person.
Yeah.
But for the majority of cases, you're going to have to deal with that person, be civil with that person, at least until that child's at least 18 years old.
Right. Yeah, absolutely. I think a lot of people have very high expectations, and like you said, it's either winning or losing, and that's just almost never good for a child.
All right, I'm going to read this. We had somebody write in. She said, explain that JC3, is it just a guideline? I'm sorry, I just don't know what JC3 is. Do you guys?
I don't understand what she's talking about.
Explain the JC3, is it just a guideline? So I don't know what that is, but she goes on to say, sometimes it doesn't work around children's activities such as sports.
I think I know what she's
Doesn't the
talking
visiting parent have to take kids to activities?
Yes.
Sometimes the kids don't want to go because they will miss games and practices. The parent won't take them. Do you have to take them to visit their dad? Do you have to take them to visit if their dad isn't available for visit, like working out of town? I'm not sure. Did you guys get that?
I think so. I think there's actually two questions.
Yeah.
Right. Does the visiting parent have to take the kids to activities? We'll do that one first.
Okay. May I?
Yes.
Okay, so in general, that answer is yes. There's usually a transportation provision in every single one of these parenting plans, at least in mine and almost all of them that I've seen, that says that, you know, either the parent receiving or the parent ending their parenting time will be responsible for transportation back and forth between the parents. And then whoever has the possession of the child at the time of a previously scheduled activity is responsible for the transportation to and from that activity. Now, some parents will try to use scheduling of an extracurricular activity as a way to get the other parent's parenting time to go away.
He gets so passionate about this.
It's the reality. So I've had to put in provisions that say, you know, if you're going, first of all, you can't without scheduling an extracurricular activity on the other parent's parenting time without their permission. So, but yeah, you'd be surprised how often that'll happen.
Oh, yeah.
You know, basketball practice is Wednesday. That just happens to be dad's parenting time. Shucks.
Yeah.
You know,
Right.
and that's what they'll do. But at the same time, how it's supposed to work, assuming both parents agree, that you transport the child to dad's house and dad is responsible for taking child to basketball practice and bringing child back from basketball practice. That's the normal rule. And if dad is not willing to take child to basketball practice, number one, that is no excuse for not having parenting time. If you do not take child for parenting time.
I'm confused.
Mm-hmm.
So, child has basketball practice, dad doesn't feel like taking him, that's
You still
okay?
have to take child to dad. If you do not take child to dad, then dad files a motion to show cause and has you held in contempt for withholding.
Thank you for clarifying.
Okay? If you take child to dad and dad does not take child to basketball practice and you have some communication between the two of you that says we have agreed basketball practice, then you file the motion to show cause to try to get dad held in contempt for not following through on the transportation and extracurricular provisions of the parenting plan. But you can't just do it on your own. You are setting yourself up for death if you do it on your own. Anybody else have a different take or want to add?
No, I think that's about right. Yeah.
Okay.
I think you answered the second question and all that too.
Okay.
So, okay, you guys continue talking. I have one more question that I gotta look up for you guys. Okay?
Okay. So I don't think we ever talked about evidence as far as a protection order. So in my experience, generally speaking, there isn't a lot of physical evidence in most of these actions. Sometimes there is some. In my experience, many parties in civil protection order actions would just love to bring the police reports.
Mm-hmm.
So I think that's worth talking about. And then I think for people who would consider going on their own without an attorney, which I don't recommend, talk about the notification of the other party of evidence that would be brought in a hearing.
Okay. So when it comes to, you know, I'm gonna deviate a little bit, so bear with me, because I feel the procedure of everything, we haven't really explicitly gone through the procedure of how the entire process works, and I think maybe that's a better understanding, just so everyone gets an understanding of how to do this. Luckily, again, I don't recommend doing this by yourself, but obviously if you don't have any other choice, essentially what you do to start with getting any type of civil protection order is you go to the domestic relations court, and you have to fill out a packet, which is about 15 pages long. It's quite extensive packet of information. You have to write a narrative as to what exactly happened that is bringing you here seeking a protection order. You have to fill out what you would deem would be an appropriate protection order for your circumstances.
What?
So they give one of the 15 pages.
You appropriate for your... I didn't understand that part.
It's okay. So, for example, you go in and you say, I need a protection order. And they give you a template, kind of like a blank template of what a boilerplate protection order looks like. And you check off what you feel. So you check off what you feel the person who is making the allegation or the petitioner in this circumstance, what they feel would be best for their circumstances.
Can you give us an example of what those are, or did you do that at the beginning of the show and I missed it?
We explained it a little bit, but staying away for a certain period, or saying a distance for 500 feet is the boilerplate one, but you can add. There's like a little line where you can add a certain distance that you feel is appropriate. If they have any deadly weapons, to turn those deadly weapons in, not to interfere in their daily life for anything with regards to employment, with regards to their housing, with regards to the mail, with regards to anything. Also, parental rights is obviously a big one that they have to check off. So you go through this whole process and you turn in the application, and what they do then is that you'll have a meeting with the magistrate typically, and you'll just explain your case basically. Explain why you feel that you're in imminent danger, whereby an ex parte protection order is necessary at that exact date.
Before we move on to this
Yes.
email here, I'm going to ask a quick question. So, would somebody calling up and threatening to beat you up be enough for a civil protection order? Or does it depend if they live with you or don't live with you? Just verbal threats like I'm going to get you or...
That's a really sticky situation. I think in my opinion, so in order, if you're going for a domestic violence civil protection order, again, there's that residential element. They have to live with you. If they don't live with you, then you have to go for what's called a stalking if you feel that's appropriate, or again, a sexual-oriented offense if you feel that's appropriate. Someone that's not living with you, that's just called you up once randomly threatening you, I think that's more of an issue you would go to the police about rather than trying to get a civil protection order, because they can do a little bit more, but with just a one instant phone call, that's going to be a stretch, in my opinion.
It has to be something pretty serious to get a protection order.
Well, may I?
Go, that's fine.
Even from a criminal perspective, domestic violence, M4, so misdemeanor of the 4th degree, the lowest level of misdemeanor before traffic tickets, right? There is a domestic violence at that level, but you have to have a threat of death.
Ooh.
So a single call for I'm going to beat you up is not enough, even for an M4. And then if you wanted to go from the telephonic harassment perspective, you need 2 calls. And 2 never call me agains. Hang up.
Really?
So if that's one time, you have not met the elements, so you're not even going to get a criminal charge. Now, will the police call that person if you have a number and tell them to leave you alone? Yep, absolutely. But that's probably as far as that goes.
Okay, let me read this.
I'm sorry, can I ask one quick question of you? Because we talked about a few different types of protection orders, and I've had this experience with people that have tried to do it, on their own, of course. But one of the issues that people seemingly run into is the residency requirement. I don't know if that's what you would call it, but if you've lived with that person, is there a hard and fast rule that how recently they would have had to live together?
That's a good question.
So some people that they break up and
Right,
they say,
right.
well, so one person they hadn't lived together for 6 months, and she went to try to get a stalking order, and they said no, it's a domestic violence order because you guys have lived together recently. So what does recently mean to distinguish the two?
That's an interesting set of facts. I mean, I would say because the CPO, when you go there, the domestic violence civil protection order, when you go there at that time, as I stated before, you have to speak about one particular incident. That's all they want to hear about.
Okay.
I would feel, correct me if I'm wrong, please, but I would feel if it's at that particular time, you are not living together, I don't feel that residency requirement would have been met.
No, it can be.
It can be?
If you have the former domestic relationship, so they have lived together as a domestic couple, they split up, and presumably the allegation would be that the former boyfriend is coming back because there still exists a dynamic that is related to their domestic relationship together. So the residential requirement would be met, I think, in that case for a domestic violence civil protection order. Now, if it's 5 years down the road and both of you have moved on, and there's been plenty of space then I think you're probably looking at stalking or sexual oriented.
But what do you think is that breaking point?
I have not seen any case law that has defined a hard and fast
Definitive
time. So I would say that it's one of those things that's arguable. It depends.
It depends.
Just put that on the wall.
Just put it right on there.
To the extent that you could come in at a full hearing or even at the ex parte level and say that what's happening now is related in some way to the domestic relationship, I think you're going to be in a DVCPO, domestic violence civil protection.
See, I can agree to that. But what my concern is, I mean, again, if there have been allegations prior to the moving out in which are kind of correlated with the actual incident, yes, I can 100% see that. But if they've been split up for 6 months and he comes back and beats her up,
I can imagine a scenario.
like I think personally I think it's up in the air.
Mm-hmm.
I mean, I think there's a valid argument for both ways, the residential requirement.
I was imagining a scenario where, you know, everything was fine while they're together, but they break up, he's still jealous. She moves on, he finds out she moved on, comes back and does something. I would put that in domestic violence civil protection order, even if it's 6 months later.
Okay.
But, you know, maybe I'm wrong. These things happen.
Okay, I'm gonna read this now, okay?
Uh-huh.
Okay, we have an email from Toma. Hello, my son. Father was granted shared parenting. He don't bring my son back sometimes. So sometime my son don't want to go when we argue. His father wasn't in out his life. Now he keep filing motions saying I wouldn't let him see my son. I missed court. So JL on case says I feel working with the father. They both said they haven't been able to contact me and the father has temporary custody. I filed motions to set aside reason for him to show cause, motion to leave, and some blank motions. The magistrate, who I feel is working with dad, a lot of people feel like that, and GAL is all up against me, the father, and the GAL refused to set up visitation, even though temporary orders say I can visit with supervision. I've been single to mother him his whole life, but I need supervised visits, not him like a stranger trying to take over. I had a court attorney who refused to help me get magistrate removed because she can't hear. I think she told magistrate, and the removal of my son is magistrate being revengeful. What can I do to get my son back? I took pictures of father on Facebook with guns and smoking drugs, filed a pickup motion, they denied it. I'm sorry, that was hard to understand. I think
There's
she's
a lot in there.
Yeah.
right, and I think she's basically, in a nutshell, I would say she's frustrated with the court, she's frustrated with the guardian, not sure what to do.
Honestly,
Any comments on this? Because I'm not sure what we can actually say.
I would say hire an attorney. It sounds like there's a lot of complex issues there. I mean, she mentioned a court-appointed attorney. That could be the abuse, neglect, dependency case, or
Right.
dad filed a show cause in which you can get court-appointed counsel for those. And she may not understand that if dad did file a show cause and she was eligible for court-appointed counsel, that counsel is there solely on the show cause issues and not for anything else, not the custody or anything else. If she has, credible evidence that this child is not safe with dad, then of course present that to the GAL. If it's a serious issue where she thinks her child is at risk, then that's also an issue for a Children and Family Services agency. There's a lot going on there. Do you guys have any other
Right,
comments?
it really sounds to me like I concur she should have an attorney, whatever it takes, because these are issues that you can't handle on your own.
Yeah.
And when you start blaming all the players in the field, right? I mean, shouldn't you hold up a mirror and figure out what you're doing wrong in this situation?
Yeah.
So-
And one thing that I've experienced with a lot of my clients is they do get so involved and they get so mad and they get so frustrated, and then they start, and in custody cases or abuse, neglect, dependency cases, you have a lot on the line, and I think it's very reasonable for a parent to be extreme because they're afraid that they're going to lose their child. That being said, though, that's one reason, even more of a reason why I do encourage having an attorney, because an attorney can be a third party, can translate what you're trying to say to the court, to the GAL in an appropriate manner.
No emotions.
Exactly.
Right.
And again, in the end of the day, I mean, what might sound as terrible as it sounds, being a mother or being a father, what might sound as, oh my gosh, I can't believe he did that, I can't believe she did that, might not actually be that big of a deal. And you bringing it up to everybody and they're all like, it's really not that big of a deal, they're in a way they're looking at like, oh gosh, now I have to deal with this, and unfortunately what a lot of people, and no one's perfect, and when someone is constantly calling you and yelling at you or going into court and being frustrated and screaming, and it affects the way they look at you, it affects their judgment of you, and it affects ultimately the ultimate decision in the case.
Right.
I don't know if you guys have had the same experience, but I think people are very disadvantaged when they don't show up to court. She
Very
mentioned
much
that
so.
she missed the court date. This is as you said, they're very emotional. They're at risk of losing their child. Get to court. That says a lot when you don't show up to court and don't communicate that or don't have a very good reason for not being there. This is your child. This is the most important thing that's happening in your life right now. Get there. And if you have restrictions because of work or other things, then the court will typically accommodate that when scheduling outside of them within business hours, of course. But they'll try to schedule on days or times where people aren't, affected as much. But
So you should always call the court. Say I have a court hearing in an hour, my car breaks down, I can't make it. I should be on the phone to the court. So they should have the court number in their phone and be able to call the court and say, I'm not going to be there today, my car broke down, right? Something. At least call, right? Don't just, your car breaks down and don't show up.
Well, certainly.
Call somebody.
Certainly that's better than not showing up at all. Even better yet is if you know that you're not going to be able to make the court date, some point in time prior to that, file a motion to continue, so that you put the court on notice that there's an issue at the next court date. And the other side, it's not fair to them
Right.
to bring everybody and show up and be prepared, and then you're just not there. If I'm an attorney on a case and the opposing party is not there, I'm asking for default judgment every time.
Really?
Every single time.
Heck
Like,
yeah.
obviously the other side doesn't care, Your Honor. Why don't you just give me everything I want?
And how many times does that get granted?
Probably 1 out of 5.
But you gotta try.
But many magistrates will give the other party one more chance. And if they don't show up a second time, you are getting everything you want.
Nice.
So not showing up to court is very, very, very risky.
Speaking of which, I just watched a case like that. It was a child support case. And he did all the right things. He served her at all known addresses, which was like 5. And then none of them were good, so he did the publication, did everything correctly, and he got his wish too. And this was a pro se litigant. He had no attorney with him. He just told me about his case, right? And I just thought it was great that he kept going to court. He kept doing the right things. He kept, filing the right motions. He did everything right, and the judge did give him what he wanted. He canceled the child support order. Just boom, done.
Good for him.
Right?
I mean, that's the rare one.
yeah.
That's what I said. I was like, I'm listening to him. I'm like, what? What?
Good for him.
Right?
I wouldn't say that that's common. So he went out of his way.
It's not.
Um,
But again, that default, right?
yes,
You
default
get
judgment.
you get what you want if the other side doesn't show up.
Yeah, I mean it's a concept that's more often used in civil cases. Somebody who's looking for money. This other party damaged me for
Oh.
a certain amount of money. They obviously aren't interested in showing up and telling their side of the case. So, Your Honor, give me an award for that money.
So like if you went to small claims court
Yeah.
for $300 and they didn't show up the first time, you'd probably get the judgment the first time.
And a small claim's probably the first time. But if
It's
you're
good to know.
in the court of common pleas,
a
probably
little different.
takes a motion for default judgment. But even then, now you've got the additional. If you're talking money, you've got to be able to collect,
Right.
which is a whole other issue.
Which a lot of people don't understand that. Yeah, you can get a judgment, but it's the collecting on the judgment. But
So back to
sometimes just getting the
family
judgment.
Away from small claims.
So, any?
We only have like 7 more minutes, so you guys are our experts. Jessica, why don't you give us some words of wisdom from a guardian ad litem about working on cases? What do you like the most about it? What do you see people do that you wish they wouldn't? Anything you'd like to say about being a guardian?
Well, I like being a guardian ad litem because you get a little bit of decision-making power. You get to you don't have somebody your client, which I love doing work as an attorney as well, but it gives you a little bit of a break from your client being like, well, why didn't you do this? Why didn't you do that? And or why should I do this? Or why, because they feel that, I'm sure you guys have had the same experience. If they're paying you, you're sort of you should do just exactly what they say. So as a GAL, you get a little bit of a break from that. You could hopefully you get to talk to all kinds of different people. You get to meet the kids, and sometimes I lose sight of that when I'm the attorney. When I represent parents, and it's really kind of improper for me to meet their children. I've had people ask, well, do you want to meet my kids so that you know who we're talking about? And I can't meet your kids, but in this case, I do get to meet the kids, and the kids are so great. They are. I mean, I just came from a home visit from here, and they're wonderful, and it almost makes you a little bit sad that at some point they're going to maybe harmed by whatever their parents are putting them through. I think that the words of wisdom, if you're in a situation, especially if you need a GAL, because GALs are not assigned for every single case. It's situations where the parents are very contentious, where there are some allegations thrown around and the kid needs a voice. If you're to a point where you need a GAL as a litigant, hire an attorney, and have them help you through navigate that process, because it's getting a little crazy and complex if a GAL is already involved.
Do you want to give your office number? Because I know you're a guardian and you also do private cases.
Yes, 440-772. Am I supposed to look anywhere specific? Oh. 440-772-0003.
And I can vouch for her. She's very good. She just followed up with one of our clients, and you sent me a text message. Worked out good.
Yeah, we had a really good result with that one.
And Samantha, your words
thoughts?
of wisdom.
Final thoughts. Oh, I can talk forever. I think the biggest thing, I work specifically with victims of domestic violence and sexual assault, and I help them through various aspects of the criminal justice system, the civil justice system, with regards to getting CPOs, divorce, child custody, all that. And it's a very difficult area to deal with because it's high emotions, high intense, and trying to explain to them the court system. It's very difficult.
Did you choose this route, or did someone push you into it like I pushed this guy?
No, I chose. I have a background in social work.
Oh.
So it's kind of in my core to really help the vulnerable, and that's typically what I do.
Good for you.
I love it. It's very difficult, but I love it. But that being said, with regards to navigating through the court system in general, it's very complex.
Yes, it is.
It's very, very complex. And, and while, I work with a lot of advocates, I work with a lot of individuals who are there to emotionally support people, they cannot take the place of an attorney. And attorneys are so necessary when you get anywhere in juvenile court. Anything in juvenile court, just get an attorney, because you're going to need one. But in general, having an attorney, it makes this situation just so much easier, and it helps you be able to cope with the trauma that you've already experienced, along with getting through the justice system.
Do you want to shoot your phone number?
Sure. So you can look for me. My phone number is 216-881-0880, and my name is Samantha Salamon. Just ask for me then. Words of wisdom. If you are trying to utilize the court system for your own benefit, for a cause that is not kosher, shall I say, for some other indirect purpose, it is not going to work most of the time. Judges can see through these things, attorneys can see through these things, and it's going to mess up your own credibility. But that being said, if you have a genuine issue, don't be afraid of utilizing the court and getting them to protect your rights in these situations.
Okay, well, how much time do we have left? All right, so It was great having the two of you on the
Yeah,
show
it was really
today.
fun.
It was a wonderful conversation. I hope our listeners got a lot out of it. I'm going to throw in my little plug there. So if you want to contact...
Go ahead and plug.
All right, so if you want to contact me, I do domestic relations and family law as well, juvenile court cases, do civil protection orders, and a little bit of criminal law. My number is 216-410-7240. My name's Eric Cherry.
Okay, stay tuned for our next month's show. We're going to have my good friend David Bartos and maybe his brother.
Wow, the Bartos.
Yeah!
All right, well, it'll be a good show. Thanks so much, everybody. You have a
Thank you.
wonderful
Thank
Sunday.
you.